Welcome, everyone. This is Tom McMillan with LEAD1. Thanks for being here today for our virtual webinar. This is our 39th webinar during this COVID period, and we thank you for being part of it. It's a really interesting, fascinating, timely webinar we're going to do today, risk management in the NIL world. We hope to get into some of the nitty-gritty of NIL. We thank Alliance for sponsoring this, and without further ado, let's turn over to Hannah, go over some housekeeping things, and then we'll get started.
Good afternoon, everyone. For those who have yet to join us for a LEAD1 webinar, I want to take the audience through a quick couple housekeeping items. First and foremost, all attendees other than panelists will remain in a listen-only mode for the entire discussion. However, if you would like to speak or ask a question, there are a number of ways which you can do so. The first would be to use the raise hand function. This is part of your control panel, which depending on the device that you're using will appear either on the right side of your screen or on the top or bottom toolbar. This will notify me to recognize you and unmute you individually. The second and by far the most common way to ask a question would be to message me directly in that questions tab, again, part of that control panel. These questions will be read aloud and that attendee will remain anonymous. And finally, you can also write a question in the chat box. However, please note that anything written in this chat box will be seen by the entire audience. I also want to make everybody aware that today's discussion is being recorded and will be circulated alongside a written recap within the next 24 hours. But with that, I will pass it back to Tom.
Yeah, thank you. Let's go through our panelists. First of all, Peter Schoenthal, who's the CEO of Alliance. Peter, thanks for being here. Courtney Altimus, who's the CEO and founder of Team Altimus. Brent Blaylock, who is the Senior Associate AD Compliance at the University of Arizona. And Alejandra Bedoya, who is the midfielder for the Philadelphia Union in the Major League Soccer League. Thanks for being here, Alejandra, and thank you all for being here. You know, what we're going to get into today is really a discussion about risk management in the sort of the NIL world and all the things that athletic departments and student athletes have to worry about in this brave new world we're heading at. So one of the first questions I like to ask Peter is, you know, how are universities going to protect their student athletes without getting themselves into trouble in the litigious world that we live in?
No, thank you, Tom, and that's a great question. So I know everyone on this call obviously is very, focused on NIL and very intrigued by NIL, although we are still waiting to see how it's going to play out because the first year especially is going to be a fill out. And everyone on this call wants to be able to protect their student athletes. And that's kind of how I got into name, image, and likeness. I was a youth football coach and was lucky enough to have athletes play all across the country. I was a terrible coach, but I was a pretty good mentor. And before I went full-time with Alliance, I was also a criminal defense attorney. So when name, image, and likeness in Florida was announced, which is where I live, the first thing that came to my mind was, what are athletes going to do, student athletes going to do with taxes, right? That was like my first concern. I don't want to represent people for free in federal court who are indicted on tax evasion. So we started looking into this. But one of the things we realized is there's a fine line with protecting your student athletes and needing something in order to protect them, but you also can't create additional liability for your universities. And the tax issue is a great one to start with, right? When you are dealing with taxes with athletes, you want to make sure that they're getting all the information that they need in order to file the proper forms, the proper documents, and have that proper information. But if you as a university are providing that information, you could be in muddy waters. So like for our company, Alliance, what we do is we provide fact tax reporting, right? We let the athletes know who paid them, how much, what state, and for what service. So they can take that information, go to an accountant and file their taxes. Because what you want to be weary about and careful of is having a software or having a company that you work with as a university or even in-house from a university standpoint and provide athletes with the forms that they need or tell them exactly what to withhold. The problem with that becomes is taxes are very specific. And if you are wrong on any of that and the athlete relies on the information provided by the university or the software that the university is paying for, the university has now created liability because your student athletes are going to rely on that information. Again, I'm a lawyer. I would have loved to have done contract forms, right? Form contracts. problem with form contracts are, as many know, they don't cover everything, right? You usually need to add things to them or subtract. But if you're providing those to student athletes and they rely on those forms and something happens with the deals that they're making, you've now created additional liability for your athletes. Same thing with payment processing. So you want to be able to help your athletes, student athletes, and guide them as to whether or not their eligibility is on the line and whether or not they're doing anything that could be in violation of their eligibility. But you have to be very careful with how far you go, and understanding liability is going to be paramount in the name, image, and likeness world. And I think a lot of that also has to do with understanding the type of opportunities your athletes are going to get and how they're going to get them. I know people are focused on the Coca-Colas and the Gatorades, but I think a lot of this is going to be micro deals, right? Anyone who has more than 3,000 followers to 100,000 followers, and the deals that they get, how they're contacted, and the pitfalls that come with them, which I know Alejandro Bedoya is going to be able to explain today on this call. So we want to protect our student athletes, but we want to make sure we do it from a standpoint of not creating additional liability for the university.
So Peter, as a follow-up question, what are some of these potential liabilities that schools may not be thinking of or be aware of that they need to be?
Yeah, it really has to do with the information you're giving and the reliance that your student athletes are going to place on that. Because if you're going to give certain information and you're going to provide reports and you're going to provide facts, and taxes is the best way to look at it, like what you need to withhold. Your athletes are going to rely on you, and if it's not correct, and it's very hard to ascertain that based on the limited information you're going to have, you're putting liability on the university. Because if the athlete's relying on it and something goes wrong, especially with the way antitrust is going to go, we have to obviously monitor that. The athlete could technically sue the university for reliance, because you're telling them, hey, this software is here to protect you, or this software is here to help you with name, image, and likeness. They reasonably rely on it. And if they get in trouble based on that reliance, that falls on the university, especially where you're licensing software for those services.
Same principle, I'm sure, would apply for telling them what agent or lawyer to pick. Same kind of principle, right?
Absolutely. One of the things that we look at is, we kind of consider ourselves like an insurance policy, plausible deniability, but we use the phrase, you want to lead student athletes to water, but you don't want to actually force them to drink that water, because that's where you get in trouble, especially if that water is contaminated, right? So you have to be very careful with how deep you go.
Let's turn to Alejandro for a minute, because you've had real life experience in this. 65,000 followers on Instagram, 235 on Twitter. I mean, you're an athlete that's learned how to navigate this world and to make it work. How do you get opportunities? How do you discern good from bad? Just tell us your story a little bit.
Yeah, certainly. I think I guess those numbers make me an influencer these days. But definitely, I started. I think gaining a lot of attention when I went to Boston College, BC, and during that time in school, I was actually playing for the youth national teams and aspiring to play in the Olympics, actually. So initially, that's kind of when I first started getting some of these opportunities. Via social media, Facebook, where smaller brands would kind of reach out, even as much as Pete mentioned micro deals. I think that's going to play a major role in here. I'm talking like mom and pop shops back in my hometown maybe wanted to reach out to me for a picture and a little bit of cash here and there to promote themselves, and my local club back in Weston, trying to offer to do private lessons here and there, which are things that a lot of these student athletes are going to be able to do. Local restaurants. When I first turned pro in Sweden, there was an American restaurant actually in Sweden where they offered for certain stipends for me to market their business and things like that. So depending on where you are in this country, some of these colleges are the main player in their communities, right? And fans are going to come out and support their student athletes, support their schools. So a lot of these student athletes have a lot of marketability in their region, so to speak. I think that's where NIL becomes so interesting, is that it's not about performance really. It's going to be driven by marketability. When I was at BC, you know, it wasn't really a football school or basketball school. It was actually more like a hockey school, right? And so those kids you would see would maybe get more of attention. So it's really interesting with NIL. You know, I think you see kids these days, the youth are very engaged on social media. They're able to accrue a large following early on, whether it's you know, part of playing their sports, making their sport being humorous, you know, working out, showing off all of their how fit they are on social media, and then they're able to get some influence. And I think that's very important to look after. And I think that's where Athlions becomes that middleman, and that getting that right understanding between inputting these opportunities and making sure that athletic departments are keeping an eye on what's going on between you know, third-party vendors and student athletes. Because like I said, these kids are coming into school already, actually being able to get some followers from high school, you know, the recruiting videos, but it's going to be interesting. Me as a soccer player was getting these opportunities back then. In this day and age, you know, you're noticing that it's the bench player, perhaps on the women's volleyball team or on the men's baseball team, that are getting a lot of opportunities to you know, promote themselves, promote their different brands, and it's just going to be very interesting.
How do you differentiate between good, bad actors, bad deals? And the second part of that, how do you avoid getting overexposed, where you're just doing everything and it's hurting your brand?
Yeah, I actually had a conversation recently with Peter about this. How, you know, I'm pretty sure everybody following this call, this webinar right now, has received those emails of like, click this link, you've won like $100,000, or receive those spam texts, you know, where you click on something and things like that. And there are, you know, just like how you're able to accrue a certain following on social media, you also know that people are able to pay to get like fake followers and all this stuff. So I think it's important that when certain people reach out to you on social media, you know, that they are who they say they are representing, and that, you know, when you take a screenshot of a potential opportunity, maybe you can input it in the Athline software and it goes to the compliance department. They're able to decipher whether it's, you know, real, legit or not, you know, authentic. That student athletes are able to also identify themselves some of these potential bad deals that can put, you know, their student eligibility in jeopardy, as well as liability in the school. So I think it's important that this is something that's talked about often, because I know, for instance, I've got numerous deals, potential deals via Instagram or Twitter, where I'd get a DM, it gets you excited, and, you know, you kind of respond to that, and all of a sudden they're asking for more personal information. And, you know, I think, you know, when student athletes see a dollar sign in front of something, you know, many of them are going to get excited, right? I remember when I was in college, you wanted all the money you can to buy some extra stuff, you know, here and there, and to go out. But it's very important. Sorry, the lights just went out. It's very important that the student athletes stay on top of this, and the compliance departments are helpful, because there are very many unfortunate, bad, negative people out there that want to, you know, take advantage of the athletes.
Yeah, I think that's a really important point, Alejandro. You know, when you were getting these opportunities, you were a pro athlete, so you got a salary coming in, so you got to be a little more risk averse. I think one of the things that when I've spoken with schools, that the worry is, you know, when student athletes that don't have those salaries are getting those, you know, getting those inquiries, and they're younger, how do we stop them from, you know, getting taken advantage of, and how, as a compliance department or an administration, how do we know about these opportunities so we can say, hey, this looks a little weird, this looks a little fishy? So thank you for that.
Well, let's go to Brent, because Brent's kind of on the front line of all this, making sure that there is appropriate compliance. But I just had a question right there. What if you're saying, yeah, that deal's okay, that deal's not good, it smells bad? Aren't you doing exactly what Peter told you not to do, which is to get to school in the middle of these deals, even though that is your job?
Well, yeah, so the important part with that is to be able to sort out, and this is going to be an ever kind of elusive term here, but what is market value, and what is good, and what is legitimate, and what needs to be avoided. So that will be the ultimate challenge with this, and this is why the institutions are going to have to know their institutional representatives better than ever. And I use that term intentionally, but because those are boosters and they're seen as institutional representatives per NCAA legislation. So their actions can and will be held against institutions if they run afoul of NCAA legislation. So the biggest thing with this, and where a lot of the burden now shifts to institutions, is that while NCAA legislation is opening up to allow these student athletes to profit off their name, image, and likeness, the impermissible extra benefits, they still exist. So you have to be very, very careful on what these agreements are, if they're even official or not, or if this is just, you know, some quick cash to do something. So we all know that this legislation is going to make boosters consumers of our student athletes' work products, services, appearances, any type of way that they can monetize their name, image, and likeness. But that agreement has to be aligned to this market value. And I mean, what is market value? Look at all the different markets that collegiate institutions are in. What, sport by sport, position by position. You know, how is that going to be determined? This market value part is what makes this so difficult for institutions. So really, it's up to the institution to ensure that its student athletes are only receiving up to this market rate within their agreements, or if not, you're going to have an impermissible extra benefit that could lead to a student athlete being rendered ineligible, which is clearly what all of us are trying to avoid in this. So, you know, we know that for the most part, and I'll speak directly to boosters, some of these third-party unconnected vendors, that's always going to be a tough space. But we know that the boosters are generally well-intending with their actions. They're here to help an individual in need. But what this means is that, you know, they can't start giving away a car they're no longer using, or a house they're no longer staying in, or just providing $10,000 because now they know that student athletes can receive cash because they feel like the student athlete's family is in need. Ultimately, these benefits, they have to be tethered to a legitimate business agreement that meets the market value. So yeah, opening this NIL door, it's very concerning in the sense that student athletes, boosters, and others will become relaxed on what these permissible and impermissible benefits are. So it's going to come down to extensive education with boosters on what they can and cannot do. And critically, a little self-promotion for my industry here, we got to ensure that, you know, athletic directors and others are reaching out to their compliance office and others to make sure that these boosters, third parties, or whomever are having continual conversations with their compliance offices on what they can and can't do and what they can and can't provide.
Well, thanks, Courtney. Go ahead, Peter.
Yeah, no, I just wanted to jump in quickly. Brent brought up obviously a hot topic, which is fair market value. And there's the kind of two issues with fair market value. Like just in general, what is fair market value, right? In normal sense, you know, you're worth what people are willing to pay you. But now you get into this weird space with name, image, and likeness on making sure that it's not being used to circumvent competitive balance and having, you know, boosters pay athletes not for their fair market value, but because they kind of just want to give them benefits that go to a school, stay at a school. I think also, you know, we hear this a lot, like, can you help ascertain fair market value? And I think early on, that's why this first year is going to be so important with name, image, and likeness. There is no market yet to determine fair market value, right? College athletes are not, you know, just typical social influencers. A lot of social influencing has to do with the market you're in, where you live, what what products you're offering. And so until we have the data and analytics, you know, maybe a semester or a year, telling people what fair market value is kind of really just a guess and putting a label on it. So that's where it's about knowing who your student athletes are working with, for what services, and having as much information as possible to help guide you from an athletic department in order to making the best possible eligibility determination. I know Courtney does a great job of kind of, you know, ascertaining these third-party vendors. Just killed a bug in my office, sorry. And these third-party vendors and, you know, how risky they are. But yeah, we hear that term fair market value all the time, and it's very interesting. And an analogy I use all the time is name, image, and likeness is kind of like an election, right? You have all these prognosticators saying what it's going to be. We're not going to know what name, image, and likeness really is until people show up and vote, right? And so that first semester, that first year is going to be so important in really understanding the landscape that we're all embarking on.
Yeah, Peter,
Okay, Courtney.
sorry. I agree, and one of the things we talk to schools about all the time, and more as we get closer and closer to that July 1 deadline, is let's focus on what you can control. Let's focus on what you know now versus what you don't know. Just like coaches have to tell their teams, you can't control the ref in a game, or you can't control, your shot if the wind takes it, if you're playing golf, whatever that is. And really right now, we know almost everything except the regulations. And obviously those are going to drive a lot of decisions. But we also know that student athletes are, they're curating their content. We've seen student athletes quoted in the news just as recently as Friday saying they're working with their family members and their teams to get deals lined up. I've had parents of Power 5 high-profile athletes reach out to me for advice on how to build out a team. I've had athletes reach out to me directly. So I think that one of the things that is so important is understanding that, yes, there's going to be things like fair market value where we've got to watch and we've got to build that data. We have to be ready for as soon as the light turns green, student athletes are going to sign because they're getting those deals ready now. So what does that mean? One of the biggest things we can do is try to vet third parties, whether they be financial advisors, agents, marketing agents, the third parties who are going to pay them. And that's what we do with our education and due diligence, but also with our due diligence software and the vetting system. And that really allows the schools to establish a uniform protocol. So every student athlete who has a deal, they need to disclose their third parties. Those third parties then run through this software, and we have a report, and then we monitor them ongoing. And it's not a full background check. It's not perfect, but at least if there's a uniform protocol and the student athletes know it and they followed it, hopefully it's going to help them, first and foremost, not be distracted from their most important roles as student and athlete by money issues or contract issues, but also help them keep what they've made. We've put such a huge emphasis on branding, which is so critical, especially around responsible branding and deal flow, like you talked about. Beyond that, what are we doing to protect them? What are we doing to help them protect that money once they've made it? And right now, a huge part of that is, not just the education, but also the third-party vetting, which ultimately will be able to hook into Athliance or whatever other platform to make it seamless. But that vetting's got to start now because they're already putting their teams around them. And what we don't want to, I think it's very difficult because schools, institutions, conferences are used to a long lead time for rule changes and then some time to implement. And by nature of what's going to happen here, that's just not going to happen. The floodgates are going to open and that's going to be it. So, I think that piece is really important, and that ongoing monitoring. Just because you check somebody out and vet them and do due diligence, if you go back story after story after story of professional athletes losing money, 9 times out of 10, it's because of a relationship they have that's been a really good relationship that goes bad. So all of these things and everything that Athliance does, all of them are great because it's teaching student athletes life lessons. We always tell them, every time you have to make a major decision in life, you're going to take a job, you need to do due diligence on that employer. If you are an employer, you're going to hire somebody, you have to do due diligence. So again, sort of focusing on what we can control, anticipating where we think the regulations may come in, but I think getting as many tools and resources to the student athletes as possible is critical. We're basically going to have, close to 450,000 student athletes for the first time in history, all have the exact same opportunity at the exact same time. And we're kidding ourselves if we're not looking at it as the rookie season of these 450,000 student athletes as if they were going pro. And we just know that from working in athletic departments for so long, and what they know now versus what they don't know. And everything, vetting those opportunities that come in, just the onslaught, the DMs. I mean, Alejandro, I know you know that. That's a lot of what, when we worked at the NCAA with elite athletes getting ready for a draft, it's a lot of what we work with them on, just a call management system. Because if you take time to answer every one of those DMs, you're taking time away from your craft and your academic studies, which could ultimately render your brand completely value of zero.
Yeah, Courtney, that's why I love talking with you and working with you on certain things, because the vetting and the constant vetting of the third-party vendors is going to be so important. And it's been talked about a lot. Me personally, on the branding and the marketing side, I do think that 95% of these deals are going to come from the micro influencer deals, where people are just going to reach out to athletes via social media, text message, Twitter, email, whatever it may be. So the importance to me is vetting those third parties, but also having compliance departments and athletic departments knowing what your athletes are doing in order to guide them from an eligibility standpoint, especially while we really wait for these rules to be ratified, right? What we're doing at Alliance is building for worst case scenario and tailoring in. And I know everyone has a different approach on name, image, and likeness, which is great. But I do believe that the branding and marketing is going to take care of itself. What's always going to be important, what's going to be needed, is understanding and knowing what your athletes are doing, vetting those third parties so you can protect them both from an athlete standpoint and then also from NCAA audits and lack of institutional control claims. So obviously at Alliance, what we do, and I've spoken to plenty of people on here, is we've created a software that easily allows student athletes to input the opportunities that they get. Also, with working, talking with Courtney and the importance of vetting those third parties, because that's what's really going to drive name, image, and likeness in the long term, to keep athletes eligible so they can, have the ability to keep earning off of their name, image, and likeness, something that they fought for 115 years. And so to me, that's the importance of what's really going to play out. Not to say that branding and marketing isn't important. It's absolutely important. But, there's going to be so many ways to get that done, so many ways to skin a cat, where at the end of the day, what is a student athlete if they're not eligible to be a student anymore or be an athlete?
Right.
Hey, Peter, I'm back. Sorry about that internet. My internet went out, but I wanted if I was listening to your conversation on my phone, and I was just curious. Can you hear me okay?
We can hear you, Tom.
We can still hear you. This is Hannah. Sorry, your video was frozen, so I just have your audio on. I'll work on.
Yeah, the question I ask is that can you ever see an adversarial relationship with a student athlete where, I come to you with a great booster deal and you say, no, that's not a compliant deal, and the student athlete gets adversarial and decides to engage in maybe adversarial proceedings, litigation or whatever. Do you ever see a tension where you're putting the compliance department in a very difficult position?
Yes and no. I mean, I think name, image, and likeness is just going to put people in a precarious situation, having to make tough decisions, right? And I think, there also is, this goes back to the liability and the risk management. You have to also be very careful with what you tell athletes. You can't physically stop student athletes from doing things. What you can do is you can let them know, you share this with us, which is going to, be required, especially on a disclosure level. And we believe that based on the information we have, if you embark on this opportunity, it's going to deem you ineligible. It's why that it's so important that, universities can't, what I call, control the money. Payment processing is going to be a huge issue. And if a student athlete goes and does a deal, and the money's sitting in an account and you are the ones that release it or not, that's weird liability. But sure, Tom, yes, there's going to be situations where student athletes want to do something. And unfortunately, based on the rules and regulations, it's going to be, if you do this, you're going to be ineligible. And someone's got to be the bearer of the bad news. You know, from a compliance level, I think the positive is you're going to get to say yes a lot more than you have in the past, which was never on these opportunities. So there'll be a little bit of goodwill there. But yes, I mean, at the end of the day, the short answer is there are going to be times that you're going to have to be the bearer of bad news. I do believe that.
Brent or Courtney, any follow up on that?
Yeah, I was going to say, as the potential bearer of said bad news, you know, if anything that the last couple of years have shown us with this litigation, it's that market restriction is the third rail. Like with all this, you can't touch market restriction because that's what a lot of this is born out of. So to say, hey, you can or cannot do these things, it is going to be very, very difficult. And I think that Peter hit it right on in the sense that, listen, this is, you know, you're a private entity now, and that's essentially what athletic departments are going to be. It's 500 private entities throughout your various locker rooms, and say, hey, it is our guidance and our recommendation that if you do this, it could be impermissible. And certainly there will be avenues to vet that out. And it's all of our obligation to make sure that we provide our student athletes with every permissible resource that we can get to them. But, you know, agility is going to be a big part of this, but it is serving that guidance to say, hey, this is going to be very, very difficult for you to maintain your eligibility and do this. I think this is also why institutions, it's got to be very clear from the start. What are the expectations and what are the areas where things will you can't go? So what are our vice categories that we're going to not approve from an institutional standpoint? What are some of our category owners that we're going to say, hey, this depending on what the legislation sorts out and it says you can't be in conflict with institutional partnerships, what are our stated areas where you can't have a conflict, and get all that out there in the front, because it's like with everything, if it's clearly communicated from the start, then everyone kind of knows the rules for engagement. But I certainly understand a student athlete's perspective where it's very frustrating, where, you know, they think they're going to sign a big deal with someone and you say, oh, actually you can't do that because it violates one of these various principles that you have as an institution. So, you know, my recommendation is just get that out as early and as quickly as you can to student athletes.
Yeah, and Brent, I think that's where education becomes a big component of this. It's why I love the universities that are kind of saying, hey, we're going to offer accredited courses to kind of help not only with your branding and marketing, but also your ability, you know, to ascertain what is going to be allowed and not allowed. So I think education plays a large part in that, which I'm sure Courtney has something to say about, since, you know, she's so great on that.
Education, really? You think I have something to say? In all seriousness, it's critical. And I can tell you from the work we're doing with student athletes now, any of you who know our programs know that we start with asking the student athletes first. We don't teach at them, we get information from them. So right now we're asking them things like, what does NIL mean to you? Do you plan to participate? If yes, how? What do you think you need to learn? So we're getting real-time data from student athletes. And I can tell you that first and foremost, yes, a lot of the answers are money driven, but I can tell you there's a lot of student athletes coming at us with, I want to be the voice for, you know, name the group that feels marginalized. I want to use my platform too. Yes, social media, but you know, you look at some of the data that came out last week that Open Doors did, and you're looking at Olympic athletes that could make, you know, $50,000 on a commercial, or any athlete, they're you know, looking at it saying they're estimating between 5 and 10K on a camp or a clinic. So all of these student athletes, I don't care what level they're participating, need the resources. They need the education. They need a place where they can ask the questions and understand how it pertains to them. And I think a lot of, you know, what we've talked about, and Tom, the question you asked, you know, what happens when the school says no? Well, I think, you know, back to what Peter said in the beginning, it's not about yes and no, it's about giving the tools, giving the rules and educating on money, educating on contracts, giving them the tools like the third-party betting software so that they can perform all of those processes and learn from them and carry them through for the rest of their life.
So we have a question. It's an interesting question. So they're asking, are schools and conferences ready to offer this education and due diligence? And do they have the budgets, qualified personnel, and expertise? They use an example. What happens if I want to hire a student athlete and I've got this great startup and I want to give them equity in the startup? Who's going to value that? Where is the determination going to be made by a compliance department that doesn't have those skills?
Yeah, so Tom, Courtney, you want to go first, or?
No, go ahead. You're the lawyer, you're better than me.
Yeah, so Tom, that's going to be very interesting. It's actually funny that you mentioned that. In our software and Athliance, we have a portal where the athletes can disclose whether or not they're getting equity in the company. You know, what's going to be really interesting, and I hate to be such a lawyer on this call, is the way we're going to get defined rules is unfortunately from litigating certain issues where the NCAA flags an opportunity, and then we have to have the hearing and the audits and then get clarification. In lawyer world, what happens is you have statutes, they're pretty vague, and then cases come out of them, the courts argue them, and then case law is created for guidance. So the answer is yes and no. We're going to have to fit, again, it's why this first year especially is going to be so pivotal, because we're going to have to really figure a lot of this out. However, I do think the schools are equipped. I think there's a lot of good companies out there that have the ability to help with education. I mean, we have someone on the call right here, Courtney Altimus, who does a great job. We do a portion of that in our software as well. But also, universities are a wealth of information and knowledge. You have your entrepreneurial schools, you have your business schools, you have people that, that are boosters that are, also entrepreneurs that you can reach out to and create those courses that we spoke about. I mentioned earlier that there's really no such thing as fair market value right now. That's true. But there is the ability to ascertain what is probably okay. And the best way a university can protect itself is by getting all of that information, asking the right questions, getting all the documentation to make their eligibility determination. So if this does go up to a conference or an NCAA examination, you can at least show how you came to your determination into saying whether or not this was something that violated eligibility or didn't. Like, that's the importance of having a software, in my opinion, to have all of that information flow through one place. So when it's time to make your case, if it so comes to that, you're ready to get up there and say, we did A, B, C, D, and E. This is how we made our determination, and this is why we stand by it. And that gives you a stronger case, in my opinion.
Yeah.
Hey, Alejandro, a quick question for you. In the locker room, how has it changed over the years now that you've become this social influencer and monetizing your publicity rights? How do your teammates treat all that? Just a curious question.
Yeah, no, I think within the locker room, once you create, you use the term broadly, the culture within the team, right? Everybody's more open to ideas and talking over what's happening in today's society, what's happening around the world. So I think, of course, everybody realizes that everybody is kind of their own brand as well, and you try to, as much as possible, given that most of us have short professional careers, you want to monetize all these opportunities as much as you can, right? So I think it takes a lot of courage to put yourself out there. I know Courtney alluded to many student athletes already coming to her, asking her like, hey, I want to represent this, I want to do that. And you can see that, and March Madness, how many people really were standing up for social justice issues and for different various things. So it's going to be crucial for those locker rooms to continue having those conversations, for student athletes to remain open. And once you're a part of a team, I think everybody can relate to. It's an amazing camaraderie that you build on, and it's one where you share a lot of personal stuff. And I think everybody is really now, after so many years of student athletes not being able to hop on these opportunities, it might be the wild west in the beginning, but I think student athletes are really going to appreciate being able to represent certain brands, being able to monetize certain opportunities, and just continue being an influencer in their own communities or on a larger scale.
So let's turn to recruiting for a minute, just to talk about that. Go ahead, Courtney.
Can I just follow up with two quick comments? One is to the locker room piece. absolutely, it's going to generate some amazing conversations. One of the things we do when we're doing education, we get a team together and we get the upperclassmen to start sharing lessons with the lowerclassmen. And we moderate that conversation to make sure that the right lessons are being shared. But it's critical, that peer-to-peer is critical, but moderated peer-to-peer for this age group and this level of experience. And I think, right now, I know a Power 5 football team, 2 Power 5 football teams, everybody's setting up LLCs. You ask any one individual why, they can't necessarily tell you, but they all know they're supposed to set up an LLC. So that's where that education piece comes in. And Tom, back to that original question about the budgets. Schools cannot afford not to educate right now. And the potential downside and the potential cost of that downside without education specifically tailored to NIL is massive. And I can tell you that because of 25 plus years of working in the business. And just real quick on the third-party vetting software, that our model, we recommend to the schools to have the third parties pay for that. Keep yourself completely out of that loop. You're giving the student athletes education, a tool to use it, an opportunity to vet, and the third parties are paying for it. So you're not involved in any of that loop of vetting third parties. Sorry, Tom, I just want to make sure we
No, it's good. Very good perspective. Brent, I just wanted to get your perspective on recruiting. What do you think it'll look like in the NIL world and some of the hurdles to overcome?
Yeah, Tom, and I think we could fill the entire time allocated for this on how NIL will impact recruiting. A couple things, and it's kind of been referenced a little bit here. The first is that you have to know your institution's value. Various programs already have recruiting materials that outline all the things that make your institution attractive to prospects. But now you have to know what are the economic points of differentiation. This is your local economy, your market competition, fan support, how your social media following and the level of engagement and how that's going to help a prospect. And also, and as has been referenced on this call many times, is your institution's NIL specific programming and overall infrastructure to set them up for financial success. How are you going to help them make money and build their brand? The second part to this when it comes to recruiting, and something we've also talked about, is getting to know these boosters and what their interests are, and your fan base. And I'll just refer to the general fan base at large as boosters. It's going to be the institution's responsibility to ensure that they understand what they can and can't do. So I don't think I'm breaking news here by saying that there have been bad actors in the recruiting space, and some may believe that this legislation will bring to light some of these nefarious activities that have gone on before. But once it's permissible for these prospects to receive compensation for their name, image, and likeness, which is baked into the current proposals, it doesn't mean that the previous recruiting payoffs that were previously laundered through a church donation can now just be handed directly to a prospect or family in an envelope. The funds have to be directly tied to a legitimate product, service, or an appearance. And within this, the kind of running joke here, but within the reasonable market value limits for that prospect. So institutions, the public, and others, you're going to get to see the money that fans and boosters are willing to spend to think they're moving the needle when it comes to recruiting. And I think that's going to be eye-opening, especially here to start. But the other thing to consider here, and this is given the volatility of recruiting, is what happens within your fan base and boosters when they provide a significant amount of money to a prospect that ultimately decides to play elsewhere. I think there are undoubtedly going to be institutions and fan bases that get portrayed in a negative light once it's publicized how their fan base reacts to a well-funded prospect that ended up going elsewhere. The final point to this, and I think it's one where we're going to be able to tell who's on mute or not, is that the current proposed legislation, it does allow for prospects to use professional service providers, including agents and specifically agents, in identifying NIL opportunities and promoting the prospect's business interests. So given that, I do not think it's unreasonable to think that we're going to get to a point where agents are now working directly with athletic directors, coaches, and others to see who can provide the best package for their client, if you will, and that will be a major decision driver for some of these notable prospects as they go to college.
Yeah, and if I could touch on that on the marketing agent side, right? Because that's a great point, and it's gonna come up, and we'll obviously see which way the legislation goes. But just because your student athletes, if they're allowed, have a marketing agent, does not mean that they're necessarily off the hook for decisions made by their marketing agent or opportunities that they enter into. Like something we do on our software is let's say student athletes are allowed to work with marketing agents, and a university we're working with allows marketing agents to kind of let the schools know what's going on for their opportunities, to submit those opportunities. Those student athletes are still going to have to attest that the information entered and that the opportunity they're embarking on is clear of any NCAA violation, and that the information being submitted is true and correct, and they need to know about it. Because at the end of the day, whether mom, dad, marketing agent, brother are helping them get opportunities, the onus and the burden still falls on the student athlete. And it's still important that they feel protected and that they know what is going on. You know, just in general, we've heard terms like Wild West and come to light. This is going to be such an interesting time in college athletics. The one way universities can protect themselves is by knowing what's going on and by knowing what their student athletes are doing and who they're working with. At the end of the day, the marketing, the branding, that is important. But the best way to protect your athletes and your university is to know what's going on. Obviously, our software allows athletes to easily submit those opportunities for compliance, to know what's going on and gather information. Because if you know what's going on, you have additional information, you're asking the right questions, you document it, you have it all together. If there's an issue down the road, you can better protect yourself. And at the end of the day, that's what's going to be important, right? We know the micro deals are going to push the day, but how can you protect your university and your athletes best? And I think as the dust settles, that's what's going to be most important, in just my opinion.
Yeah, and the other part with agents too, you have to thread the needle a little bit on this, but because they are allowed to have agents to help with these marketing opportunities, but the other parts of the impermissible agent legislation still apply. So, you know, if you have a student athlete or a prospect, as we're talking about, this agent can help them get the sponsorship deal. But as soon as they reach out to a professional team to say, hey, can we help arrange a workout, or what do you think of my client, this or that? Well, they're now marketing the professional services on behalf of the student athlete, and that's still going to be a violation. That still often comes with permanent ineligibility. So it's not a wide open array of services that these agents can provide. It's still got to be targeted in these very specific areas.
Yeah,
To Brent's point, though, it will depend on the congressional legislation, because
Right.
some of them allow much more open-ended relationships with the agents, including professional opportunities. But, you know, I hear your point, and that's the way it is today. Did you have a comment, Peter? I have a couple questions.
Well, I was going to say two things. Tom, you nailed it on the head, though, which is at the end of the day, what we're all talking about is worst case scenario. We have to monitor the legislation. Nothing has even been ratified on the NCAA level. We're still monitoring the federal level. We have a general idea of what things are going to look like. But at the end of the day, you always have to be able to evolve as a software, as a company, and as a school with name, image, and likeness, depending on where things are going. And I just want to say, Brent nailed it on the head with the agent as it pertains to marketing and then other aspects. It's why we love working with Arizona, right? Find people who are smarter than you and work with them. So thank you, Brent, for that.
We got an interesting hypothetical question. So let's assume I'm a student athlete. My appearance value is 2,000. Everybody's okay with that. I do a few of those. Then in turn, I go to the school and say, I want to donate my appearance value to the school. I want to take the tax deduction to $2,000. And by the way, don't ask me to do any more appearances for the school unless I make that donation. Isn't that a slippery slope?
Yeah, that's absolutely a slippery slope. And I have no problem saying in certain scenarios, we have to wait and see, or even, I don't know. That is a very heavily driven question by legislation. We're gonna have to monitor the legislation on that. But that's a very interesting scenario. I think everything was sounding interesting until the end, where it was like, and if you don't let me do this, I'm not doing anything else for you. I think
No,
that's,
that was my add-on to the question.
Okay.
If I'm donating to the athletic department, to get a tax deduction, why would I do free events for the, isn't that sort of the pay for play kind of angle you're sliding into?
Yeah, well, Tom, I think you can back that up before you even make the donation. I think, you know, we talked about institutional and student athlete conflicts earlier, and I think one of the bigger ones are going to be the promotional activities. What happens to your fan day when you have your student athletes sit out there and sign autographs for 2 hours? Everyone knows they're now devaluing their public values. If you can go stand in line and get the autograph, why am I going to go pay $100 for it? Why am I going to bid for it in these other places? So you hate to say it, but there will be some level of almost not contractual agreement, but understandings of like, hey, yes, if you're a high profile, high possible market value student athlete, like you still have to do certain pro bono, to use the term, which is amazing to say with a student athlete, marketing appearances for the institution. You still have to show up when we're going to this local commercial entity, even if it conflicts with an agreement you have with somewhere else, or you still have to sit and take the pictures and sign the autographs and do all those other things, because that is going to create some tensions. It's one of the things people love most about college student athletes is that accessibility. And so now how are we going to intertwine the two?
Courtney, any comment on that, Courtney?
Well, I think, you know, if they're still getting their scholarship and any part of that piece of the legislation is close to what the proposed legislation is right now, they're required to continue to do appearances for the school without getting paid. The donation piece is interesting because, again, as it's written now, they can't charge the school for their services. They can't perform services for the school, but donation is different. So it's going to be interesting to see what happens with that. I can't imagine they're going to, they can't tell them who they can't donate money to. But that's why we have Congress involved, I guess.
And that's why, you know, we're bringing up a lot of fringe cases, and unfortunately that's going to have to get litigated out, which is why you have to be prepared and have all of this information. And, you know, I've heard analogies like the NFLPA and the NFL and how the athletes work with the team. You've got to be careful with those analogies because they don't really work, because now you're getting into employment versus amateurism talks. So they aren't apples to apples, they're apples to oranges. So again, these specific questions we're getting is why it's so important that we have ratified legislation and understand the landscape that we're entering into, because those fringe cases won't be dealt with even in legislation, although it'll kind of direct us down the right path. And then it's going to be up to the universities to make sure they document everything. So if these cases do get litigated, you can protect yourself and your universities.
Go to that point for a minute about disclosures. You know, we know how important that'll be about disclosing all the fullness of a deal. What is something universities aren't thinking about with regard to disclosing these opportunities? Is there, you know, Pete or Brett, do you have any perspective on that? Some of the challenges on the disclosure side.
Yeah, I think it goes back, and again, we have to wait for the legislation and see what needs to be disclosed and kind of get directives on that. But obviously, there's going to be some form of disclosure. I don't think anyone argues that. And so the best way to, for me, you know, running businesses before, is if you're going to have to disclose to the NCAA, kind of do them as an IRS, you're going to need something like a QuickBooks that kind of gathers all of that information that allows you to easily organize it so you can disclose to the NCAA. And if an audit does happen, you have all that information, okay? So you could say how you came to this determination and how you know, made your eligibility determination. So the disclosure is, you know, what needs to be disclosed is going to be really heavily determined by legislation, but you're still going to need something, in my opinion, that helps you gather the information that needs to be disclosed to the governing body, which will be the NCAA.
So a couple questions. What if you're a student athlete without a major social media following? Will you be able to benefit from NIL?
Absolutely.
Anybody?
Absolutely. And I think, you know, as I said, we're working real time with student athletes about this. One of the first things we do is have a goal setting session for them. So, you know, we tell them whether it's branding or compliance or making money, if you're not understanding who you are and why you're involved in this, it's not going to be successful. So it could be an Olympic student athlete who does not want to graduate with any debt. So they're focusing specifically on local appearances or camps and clinics. I brought up the commercial example earlier. I think we're going to see some D3 athletes who have incredible talents off the field, off the court, and all of a sudden you're going to start seeing some attendance increase at some of these events. And, that will generate more. So I think it's critical that student athletes are looking at this and thinking of creative ways. Social media is but one opportunity to benefit from name, image, and likeness.
Yeah, Courtney, you hit the nail on the head, which was the camps, personal lessons. Like there's so many things that athletes will be able to do that aren't even necessarily social media driven. So yes, they'll absolutely be able to profit off of their name, image, and likeness even without a large social media following. But I think what gets lost in the shuffle is what is a large social media following. I mean, in today's day and age, if you have over 3,000 followers, you can make some money off of your name, image, and likeness. And we know that many of these athletes, a large contingent in the NCAA, have that. And Alejandro alluded to it earlier. It's about marketability, not performance, which Courtney just touched on, which is, talents and traits away from their sport. And so one of the things that, and Courtney, feel free to use this, student athletes need to be worried about is there's the who you are, but now there's the what you are, and the what is your brand and your abilities and your ability to earn that you need to be able to always protect.
Well, kids can write. Go ahead, Alejandro.
Yeah, no, I don't want to promote this brand. I have nothing to do with them at all. But I'm sure many of us are on this webinar have maybe heard of the company Gymshark. But like I said, a large social media following is not instrumental to being able to get some of these marketing opportunities. What this business did, they literally reached out to numerous people who, they're a gym kind of culture brand. And this could be all these student athletes who could be potential trendsetters within the communities, D1, D2, D3 schools in their local communities. And they offer them, not much money to promote their brand. You post some stuff with their clothing on or whatever, and that's how they grew. And they're now valued at over $1 billion company, and just these little deals, micro deals that many of these student athletes can have access to. That's just shows the many possibilities.
Yeah, Gymshark started, I believe, as like a clothing apparel for the gym company in a garage, and they would contact people who had more than 3,000 followers that were young and in shape. They'd offer them clothing, sometimes a little money. They'd post, and the next thing you know, they were a $1 billion company. And that's the type of reach that these student athletes will be able to have now, because they'll be able to work with companies like that. One thing that schools need to worry about is supplements, right? People that have, decent followings that are in shape. You have companies like RSP and many supplement companies that are going to reach out. Now you have to worry about what your athletes are putting in their body. So again, this is going to go many different ways, and it's just about, staying as educated as you can, especially early on, in my opinion.
Lots of ways, writing, photography, lots of ways to make a dollar here. Here's a question. What are some ways lower resource institutions might be able to manage the vetting of outside vendors and create education absent any external monitoring software? In other words, what if they're really just trying to make it and they don't have resources?
Yeah, I think
sorry. No, I think that'll be difficult. It's why we're doing a pilot year one. If you want to check us out. But that will be difficult. But the education component, I mentioned it earlier, creating courses, right, for your athletes, student athletes, where you can give them actual credits for things that are surrounding name, image, and likeness, because education is going to be one of the factors as to how often athletes violate their eligibility. Knowing the rules, what you can and can't do, is so paramount. And I'll turn it over to Courtney because I know she's so passionate about this.
I am, and we've been working hard to make sure that we have offerings for lower resource schools. So I would just say that anybody who doesn't think they have the budget, they should definitely reach out, because there's certainly pricing tiers. And on the third party piece, almost impossible to do any kind of mass vetting without software. But there are processes to teach student athletes and teach them how to vet on their own. And I would encourage schools to reach out about that as well.
So we're kind of down to the last couple minutes. Do you think the Supreme Court decision will have any impact on NIL, Peter? Giving you legal back?
I get this question all the time. So Alston was a very interesting case that I really, me personally, don't think it has too much of a bearing on name, image, and likeness, other than, you know, who could sue the NCAA and even universities, but mainly the NCAA. Because what was really being discussed in Alston was whether or not there was antitrust exemption on the NCAA level. Nothing more, nothing less. When the Supreme Court argues and decides something, it is based on what is certified from the lower courts. And all that was certified was that antitrust exemption issue. It is totally normal in Supreme Court hearings for the Supreme Court to crush both sides. And we know how the media views the NCAA and college athletics. So I know everyone saw the part of Clarence Thomas, you know, with his comment, which is basically, what do you mean athletes don't get paid in today's day and age? And everyone ran with that. But the other side that no one was talking about was when the DOJ, Alston, the NCAA, and the Supreme Court all agree that the NCAA needs power in order to effectuate its rules, in order to make sure there is competitive balance across the board. So as it pertains to Alston, it really is what kind of lawsuits can be brought. But other than that, it wasn't, to me, in the context of NIL, that big of a deal. I'm sure some people disagree with me, but that's my take. That's a hard question, Tom.
Yeah, well, it's one on everybody's mind, you know, as it's coming right around the corner. So let's go for final comments. Courtney, you first.
There's risk that we can mitigate against, and there's risk that we don't know what it's going to be until we have the definition of the legislation. And schools absolutely need to be setting up tools and resources for student athletes to protect and to mitigate as much risk as possible now.
Brent?
Yeah, I would also just push the education, getting out in front of things, and a term I heard recently that I think everyone needs to think of is you got to be a globally minded localist. You have to understand everything that's going on across the country and globally, because this does pertain to international student athletes as well. But you really have to know your local market, your local fan base, and all those as well to best wade through these waters.
Alejandro?
Yeah, I mean, we're talking college athletics here. So I think back to university, the key word is education, and that's on all fronts, right? For compliance departments, for all the compliance officials to be educated on all the key topics at hand, and to be keep an eye on all the legislation coming in. But for student athletes as well, be educated on what's happening in the NIL space, but also, you know, in terms of financial literacy. You know, I think trying to understand what's going to come across their DMs, their social media platforms, in terms of contracts and you know, monetary opportunities. So just education is key.
Peter, final word.
Yes, first of all, thank you everyone for joining. But whenever you hear about risk management and liability, you need ways to protect yourself. And oftentimes that's an insurance policy, right? What we kind of do at Athliance is we provide that insurance policy and a little bit of plausible deniability. And the key for universities to protect their athletes and themselves is you need to know what your athletes are embarking on. You need to know who they're working with, and you need all the information that you can get in order to make the best possible determination in order to protect yourself down the road, right? We talk about the totality of the circumstances. That's what, you know, normally happens when you're being, you know, investigated for certain things, and what you did to protect yourself and to make your determination. So branding and marketing are great, they're fun and they're sexy, but what's going to be most important in my mind, and what's going to drive name, image, and likeness, is your ability to protect your athletes and your university by knowing what's going on. And so obviously our software easily allows athletes to input what they're doing. I've met with a lot of people who are on this call. We just released our new and basically final version of what the athlete portal is going to look like. I encourage you to set up a meeting with us at athliance.co to check it out. But just find a way to know what your student athletes are doing so you can best protect yourself and them.
Well, thank you all for being here for this fascinating discussion. Thank Athliance for their support, and we will be watching very carefully as NIL comes upon us in the near future. So thanks so much, and look forward to reconvening.
Thank you, Tom.
Thank you so much.